my pleasure to be here today. In terms of a little bit of background, when we're talking about the Personal Directives Act received royal assent in May of 2008, and what that means is that it got through the first gate of government. So as a statute or as a bill, it actually was approved in principle by the people who were sitting around the cabinet table at that point. It has been proclaimed already, and it will come into force April 1st, as mentioned. And the Act and all the associated regulations are actually currently online at those addresses listed below. So if you were interested in actually going in and looking at the statute specifically or looking at the associated regulations, they're there posted on the website. In terms of the purpose of the Act, it will allow Nova Scotians, and it's really important, and part of it, the insight and part of the epiphany that we had when we were delivering this presentation to program staff, is that they thought that this Personal Directives Act was just for the clients. And we're saying, well, no, it's not. It's for all Nova Scotians. And so that would mean myself, everybody in the room, family members could also have the ability to prepare personal directives that would articulate their wishes or their instructions related to personal healthcare decisions in the event of becoming incapacitated. Now, incapacitated, they could become either temporarily or permanently incapacitated. So it's important to understand that this is a document that it's a legal document that you would have at your disposal to actually articulate your wishes around this particular decision area. As well, in addition to including the details around how you would want things to go, your values, wishes, or instructions related to personal healthcare decisions, it also allows you to name a delegate to make some of those decisions on your behalf. And that's an important point because we actually there's, as we'll see in further slides or future slides, that there is some gap in legislation right now for decisions to be made for individuals outside of the hospital with respect to healthcare decisions. So that's a really, really important aspect of the Act. The other part of the Act that, in terms of the facilitating mechanism, is that for those folks that don't have a personal directive, particularly with a named delegate, which would be by and large everybody, for the next 5 or so years until we sort of get the public education piece going, there is a mechanism within the Act that allows for the identification of a substitute decision maker based on a hierarchy that's aligned as of April 1st with the Hospitals Act and with IPTA, to identify a substitute decision maker. And the difference between somebody who's identified as a substitute decision maker using a personal directive as the delegate, or somebody who's named as a substitute decision maker, or you'll see the terminology we're using for a substitute decision maker identified using the hierarchy is a statutory decision maker, lots of mouthful words, is that it's a limited scope of decisions that you can make actually. So instead of with the personal care decisions, you'll see the next slide is quite broad, but if you are appointed under the hierarchy, it's only 3 areas of decision that you have authority to make. So it's home care, health care, and placement into a long-term care home. So I won't read through all of these, but this is just to give you an idea that we're actually talking about a broader scope of decision maker than we might have been used to seeing under perhaps something like the medical proxy. So with a medical proxy, you're used to seeing just healthcare decisions, particularly made in an acute care environment. But here we're talking about a whole bunch of different things. We're talking about not only healthcare, but nutrition and hydration and support services and hygiene as well. So somebody could actually give instructions in a personal directive related to all of these areas if they had something particular that they wanted to articulate. In a personal directive as well, somebody might just say, I just name my spouse to make all my personal healthcare decisions, and not have any of that detail, and that's valid as well. But just to give you an idea about what we're actually talking about in terms of personal health care, and this scope of services is actually embedded in the statute. Now, why do we need this Act? Well, it provides protection for a number of areas, of course. It provides protection for clients, so it gives them the ability to actually make their wishes and their rights and their instructions and their wishes and values known in a legal document. It also provides some protection for family decision makers with respect to, it gives clear guidance and legal protection with respect to their wishes related to a loved one around this area of decisions. It also provides some protections for healthcare workers and administrators, again giving clear direction for getting consent for services. It's also, there's much more structure and accountability and legal protection, as well as some assistance with some family conflict resolution. So as I'm talking to you, primarily I deal with care coordinators in the continuing care field, and I know that there's a lot of Conflict resolution is an aspect of their job, and I think as healthcare providers, there's a lot of those delicate conversations that you're having with family and loved ones, particularly if they're in crisis. So the thought around this is that if there is a document that articulates the loved one's wishes and instructions, it actually helps and facilitates that discussion a little bit. So if one exists, it does provide some of those protections and facilitates that discussion. In terms of planning for the future, it's important to understand too that a personal directive is just one of many planning documents that a person might use to ensure that their wishes and instructions are articulated. Some of the other mechanisms that might include that you might be familiar with is medical proxies made out of the Medical Consent Act. What's important to understand though with respect to the Medical Consent Act is that as of April 1st, when the Personal Directives Act or PDA, I'm used to using all the acronyms, so if I do, somebody can throw something at me if I'm using too many of them. But when PDA comes into force April 1st, it'll repeal the Medical Consent Act. So what that means is that nobody will be able to use a medical proxy after April 1st. They'll have to defer to a personal directive to actually articulate those wishes or needs related to personal care decisions, which include healthcare decisions. As well, in terms of planning documents, of course, there's the enduring power of attorney and there's wills. An important point as well is that under this new act, PDAs or personal directives from other jurisdictions will also be recognized, but with the caveat that we won't, because we have things in our jurisdiction that we don't consider legal, like assisted suicide. If somebody coming from a Scandinavian jurisdiction that had something like that articulated in their personal directive, we wouldn't abide by that, just because it's not legal within our jurisdiction. In terms of the current situation, I inferred to this or made this point a little bit earlier, that the current legislation only allows for a person to appoint another individual to make healthcare decisions, and that's under the Medical Consent Act, but it is very limited in scope in terms of that authority that individual has if they're named as a medical proxy. For those individuals who have not made an authorization under the Medical Consent Act or don't have a guardian as appointed by the courts, there's no legislation right now that allows for an individual to be appointed or named as an SDM or substitute decision maker to make those kind of decisions for an individual outside of hospital, so in the community, which is a really, really important point. It's a huge gap. As well, in terms of placement in long-term care as well. Adult protection might become involved, but only if the assessed risks meets the program parameters. So there has been some challenges in the past where you sort of get to a point you're not quite sure what to do, and there's a referral that's made to AP. So certainly that opportunity and that mechanism is still available to you, but only if the individual actually meets the assessed need based on the program criteria. In terms of the personal directive as a document, any capable Nova Scotian can make a personal directive, including a mature minor. Now, we've deliberately and intentionally not defined mature minor because it is situation specific, but there might be, for example, somebody who has been involved with the IWK from birth because of a chronic illness, and at 12, he fully understands his condition and he's fully able to articulate his wishes and beliefs and values related to what his course of care. So it's recognizing that he has the right to actually develop that document if he wants to do that. It must be signed, dated, and witnessed. The witness cannot be, and this is also embedded in the statute, a delegate, a spouse of a delegate, a person who signs on behalf of the maker, or the spouse of the same. You don't need a lawyer to do a personal directive, which is a really important point in terms of its accessibility as a document for individuals. And a personal directive is considered a legal document if it meets all the above noted criteria. And of course, a personal directive takes effect when somebody loses capacity. So it's like an EPOA, it's like an enduring power of attorney, there is a trigger point. So a personal directive isn't, even if there's somebody named in there as a delegate, that delegate can't make decisions on an individual's behalf unless that individual who crafted the personal directive has become incapacitated. In terms of consent to care and treatment, again, it's very important to understand what we're talking about in terms of a definition of capacity, because that capacity is one of the key elements of this particular statute, because it's all about capturing consent to service, and someone has to have capacity to consent to service. So this definition is actually embedded in the statute. And capacity with respect to the Personal Directives Act, it means the ability to understand the information that's relevant to the decision, and the ability to appreciate the reasonably foreseeable consequences of making that decision or not. Because there are individuals, and certainly we deal with them in terms of our client population, where they have capacity, we've assessed that they're at risk, but they can choose to live at risk because they have the capacity to make that decision, and that's part of that whole allowing them the dignity to make that choice, although we might disagree with it as healthcare professionals. So that's one of the struggles that certainly when I'm dialoguing with my continuing care colleagues that they're dealing with on an ongoing basis out in the community. Again, one of the things that's important as well to differentiate with when we're talking about assessing capacity to consent, we're only talking with respect to the PDA for decision specific. We're actually talking about the conversation that you're having at that point in time. So for us in continuing care, it might be about a home care treatment, it might be about a placement decision, it might be perhaps about nursing coming in for IV therapy, but it's decision specific. So we're not actually talking about global assessments of capacity, because for our care coordinators as healthcare professionals, that's beyond their scope, and we don't expect them to do that. We just expect them to actually be able to assess that person's ongoing ability to engage in that conversation, to be present in that conversation, and understand what it means to make the decision before them that they're being asked to make. Again, capacity to consent, of course, may fluctuate, right? So, particularly with dementia patients, they may not lose their capacity to consent to care at one moment in time. And as well, related to this, a person, and this is part of the dignity conversation that we're having with our clients, is that they might be able to make a simple decision. They might be able to consent to a flu shot, but they might not be able to consent to a very complex surgery. So it's one of those things where, it's always an organic conversation where you're having with the client and you're allowing them the dignity to be involved in in their decision making based on what they're able to decide and the consent that they possess at that moment in time.